You do, yeah, you do. You have Mr. Supervisor McEwen, Supervisor Leahy, Supervisor Stark.
Supervisor Jean contacted me, and he may need to join us late, but he's got a conflict. So,
I do have to leave at 5 o'clock for about 5-10 minutes for appointment for the tech.
yeah, we'll try that. All right, we'll call the meeting of the Human Resources, Finance, and Property Committee to order. Does anybody wish to make a public comment? Any public comments? If not, we'll close the public comment period. Supervisor Zhang had a conflict. He hopes to join us later. So he will be marked as excused unless he shows up. Approval of the minutes from the March 23rd meeting. They're in the packet. What are the wishes of the committee relative to the minutes?
Move to approve.
Been moved. Is there a second?
Second by Fisher.
Moved by Gibbs, second by Fisher to approve the minutes of the last meeting. Any discussion? If not, all those in favor of the motion to approve the minutes will signify by saying aye.
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 Opposed, no. That motion carries unanimously. Thank you. Educational presentations, the American Rescue Plan. Do you want to just go over the highlights? You want me, or what do you want to?
Do that together?
Sure.
You or me first?
We always look to administration for for guidelines, embellishment.
Yeah, embellishment is a good word.
Embellishment.
Thank you, Mr. Chair. This is Administrator Leonard. For those of you that have been away from your email, you'll be happy to know that the U.S. Treasury Department did release 151 pages of guidance relative to the American Rescue Plan yesterday. Again, just to ground us all in the allowable uses under the Act, there are several categories. First, to respond to or mitigate the public health emergency with respect to the COVID-19 emergency or its negative economic impacts. The second is to provide government services to the extent of the reduction in revenue. Third, make necessary investments in water, sewer, or broadband infrastructure. And the last broad category is respond to workers performing essential work during the public health emergency. There are also some general areas that the Act sought to limit the utilization of funds, but we can talk more about those at a future date. I mean, again, it's 151 pages. We have a lot to go through, and there is a lot to go through. The first 129 or 128 pages are largely kind of narrative explanations of the intent of the guidance, I'll say, characterizing what the guidance is seeking to accomplish and giving some high-level examples. But we have a lot to learn. I've read through about 2/3 of it to this point. Again, there's a lot to dive into. But with respect to a couple big areas that I think we still need to learn a lot about, with respect to response to or mitigation of the public health emergency, I think there's some good language that we'll need to delve into moving forward. There is the ability, there appears to be the ability of counties to utilize the funds. Again, Marathon County is receiving about $26 million, in excess of $26 million under the American Rescue Plan Act. You can utilize those funds for mitigation efforts, which does include the modification of infrastructure within some public buildings. I think that's a positive that is laid out in the guidance. So modifications to ventilation to prevent the spread of the virus. Public building mitigation efforts are likewise within that first category. There's some pretty expansive language around behavioral health services. The guidance recognizes, I think everyone would agree with this, the guidance recognizes that the public health emergency. The pandemic has led to a significant increase in utilization or the need for behavioral health services, mental health, substance abuse services. So there's some language there that we need to look into and make sure that we're allocating necessary resources in those areas. With respect to providing government services to the extent of the reduction in revenue, I think that's one area where there's substantial language that we need to sit down with Christy and her staff and hopefully get a lot of assistance from both Wisconsin Counties Association as well as the National Association of Counties to understand how a reduction in revenue is calculated under the act. Excuse me. And this is my understanding right now, so I can guarantee it's wrong, but I think it's perhaps somewhat valuable to go through. The act and the guidance seems to provide for local governments to essentially estimate what would have been their revenue growth over the period of the act, and then utilize Rescue Act funds for a wider range of projects as long as you're within that, your spending is within that projected revenue for each of the 4 years of the terms of the act. So, for example, if our revenues through 21, 22, and 23 are relatively flat, but our projections would have been under the act 4.1%. They allow you to project annually a 4.1% revenue growth. We could utilize those act funds for a wider range of projects for that gap between what would have been under the projection are available funds and the funds we actually have available. So that's something we certainly need to look into. With respect to the third category, making necessary investments in water, sewer, or broadband infrastructure, most notably as it relates to water, they utilize some existing criteria from previous Clean Water Act provisions to really provide guidance on what are suitable or eligible water and sewer projects. With respect to broadband, they have pretty substantial goals or thresholds that they really are trying to get local governments to allocate those funds to pursuing, and I'll allow Supervisor Robinson to speak to that. And the last thing I'll talk about is one area where I think we need to really understand what the act permits is around the utilization of the funds for eligible expenses for eligible workers. So to the extent we're able to utilize the existing funds for covered expenses, those things include payroll, leave benefits, paid time off. We want to make sure that we evaluate whether or not it's appropriate or fiscally responsible to utilize those funds to shore up any liabilities we may have in those areas, because certainly under the pandemic, we limited individuals' ability to utilize leave. So that is, in essence, an outstanding liability on the county's books. People didn't utilize the leave that they were accruing throughout the last 15 months. So the act has some language there that I think is relatively expansive for certain eligible classes of workers, and that may include all government workers. I need to, again, do some more research relative to the guidance. But the guidance, again, was released. We'll send that. If anyone does not have it, we'll send it to all committee members. It's 151 pages. So that's the high-level overview relative to what I've been able to find. And with that, Chair Robinson, I'll turn it back to you to elaborate, and certainly elaborate on the broadband piece.
Well, I think the reduction in revenue is something that I listened to a NACO presentation. I think they're struggling for interpretation, but that 4.1% increase seems to be the driver that may benefit us. But what it would allow us to do is free up those dollars and to potentially apply them to otherwise ineligible projects, which could include capital or services. So I think we need to look at that. But one of the components of the water and sewer is stormwater. While the county doesn't deal with the issues of water and sewer, there may be some opportunities for us to look at stormwater improvements at facilities and in projects. So I think that's something that we might want to look at. On the broadband side, NACO was still trying to understand the ramifications of it, but it looks like the expansion efforts and the use of the dollars are associated with a 100 megabits per second upload and download speed. So it may be available for other projects, but we will have to look at those provisions to determine where we go. But we've already started having discussions with some of our ISP, Internet Service Provider partners, on where that may go. But my suggestion is that we devote a good section of our educational meeting to getting a better understanding of what the opportunities are. The City of Wausau will be having a hearing tomorrow evening at John Muir at 5:30 to begin the process of getting public input. I think the concern that this committee had last time, instead of joining them, was we wouldn't fully understand where we could use the dollars. And with the rules coming out yesterday, we are probably going to be searching for clarification and meaning. In the future, we don't want to be spending money in areas that might be questionable and we would have to reimburse. And we also want to be cautious not to spend money on things that are continuing obligations that would create some liability going forward. So we'll work with administration to try to get a better clarity on where the American Rescue Plan dollars can go. The one thing that was pointed out by NACO today is that in addition to the direct allocation to the county, there will be dollars flowing through the states. Many of those will not have some of the requirements, and while there are prohibitions on using the money the county receives for pension benefits, historic and other activities, lowering expenditures. In others, there are a number of opportunities for us to use the state dollars to potentially fund some of those activities. So we'll need additional clarification, but there's a lot of opportunity associated with the allocation. We just have to be prudent and careful in how we do it, and we have to incur the costs by December 31st of 2024 and actually expend them by 2026. So there's a window beyond incurring the cost to actually spend it, and anything that is not spent after that would have to be returned. So any questions relative to the rescue plan? But again,
John, this is Craig.
Go ahead, Craig.
Thank you. John, is there any restrictions on CIP projects?
The capital improvement projects?
Yes.
Well, the infrastructure improvements, well, the explanation today is that we can look at taking some of those proceeds to look at capital expenses associated with COVID compliance. For instance, in the jail, if we needed to do additional spacing because of concerns over the spreading of COVID, we could hypothetically look at the cost associated with the accommodation of those housing needs as a eligible expense. We couldn't use those dollars to pay for a new jail. So they have to be directly related to COVID. We cannot, at the present time, use the dollars for roads and bridges unless it's part of that revenue loss and reallocation. So there's really limited. We can look at it in the context of, again, our broadband. Probably the county doesn't do sewer and water, so there's a potential for stormwater projects that would be associated with it. But the capital side, there may be some potentials for behavioral health services. I think we would want to explore those for North Central Healthcare, but we're still learning what those provisions might be. Does that help, Craig?
Yeah, and so just hypothetically, if, say, a county wanted to expand their morgue services, would that, if, I don't know if that would fall under that?
I think it would be a stretch unless those were COVID-related deaths. But you'd want to, I think that would be one you'd want to make sure you had clarity for before you did it, so you wouldn't pay them back.
The only other thing I'll add, Supervisor McEwen, is building on Chair Robinson's earlier point. You could expend those dollars for a capital project if you fit it into the bucket of providing government services to the extent of the reduction in revenue. If we do the kind of the projection methodology that's laid out in the act, which it allows for you to essentially project, again, 4.1% annual revenue growth during the period of the effective period of the act, or there is an alternative, which is what your actual revenue growth has been. I believe it's over the last 3 years, whichever is greater. But in either event, you could utilize, then there's less restrictions on those funds. So the way that I'm thinking about it right now in my head is there are 3 ways you get into a capital project that you might be able to use this funding. Number one, it's a capital project, as Chair Robinson referenced, that is directly tied to the response to the pandemic or the mitigation of the public health emergency. 2 is that revenue reduction methodology. Or 3, it's a capital project in that area, in the area of water, sewer, broadband. You have to, in either instance, you need to very clearly articulate how it is eligible under those categories.
So more to come.
Thank you very much.
Other questions? Other questions?
Supervisor Fisher here.
Go ahead, Jonathan.
So last night I did actually watch, they had a Zoom call regarding some of the rollout features that I participated in last night. And you are correct. One of the items was in regards to the broadband expansion. For homes not currently receiving a wired connection, you know, driving the 25 Mbps download and the 3 Mbps upload, which I think would be relatively reasonable, especially kind of up here in the North County area, and to continue to push for that. I know, for instance, the town of Berlin literally just got internet connection at the town hall a few months ago, which is, you know, what is this, 1994? But, you know, the other one was a minimum of 100 Mbps download and 100 Mbps upload, which is, I mean, I'm on Charter and I don't even get that. So I'm not exactly sure how we'd meet that ramification, and if that would just be in relation to actually digging, you know, trenching wire around the county area. So I don't know if that's one or the other or both, but, you know, those are pretty diverse from each other.
I think, again, NACO didn't have an answer for that today. I think we're still looking at it. There is ever-evolving technology relative to wireless, but generally when you start getting into those speeds, you're looking at fiber.
Right. Okay.
But
Okay. Excellent. Thank you.
I would encourage you to attend next Monday's Broadband Task Force meeting to learn more.
I will be there yeah, I'll be there.
All right, anything else? Okay, we'll move on to operational functions by statute. Tax deed bid opening approval. Kim?
All right, we have quite a few of these today. Item A for 1427 Lake Street, we received no bids. So moving on to B, 315 North Fifth Avenue, I have 4 bids. The appraised price and the price, the sale price that you set was $15,000. And just for the record, I have all these bids in the order in which I received them in my office. So that is how we are opening them. So purchase price was $15,000. The first bid I have is for $26,105, and it is accompanied by a bank check for the 10%. Second bid is for $31,500. And it is also accompanied by bank checks to total the 10%. Bid number 3 is for $30,000, accompanied by a bank check for 10%.
So we have 3 bids, the high bid being 31,500. What are the wishes of the committee?
I have one more.
Oh, I'm
So
sorry.
it's 4 total.
There were 4 for this property. I have one more.
I apologize. They were going up, I was kind of,
Yeah. And bid number 4 is for $20,000, accompanied by a check for 10%. So the high bid is still bid number 2.
at 31,500. What are the wishes of the committee?
Make a motion to accept the bid of $31,500 for the property at 315 North Fifth Avenue, Wausau, Wisconsin.
Is there a second?
Second, McEwen.
Moved by
Second.
Moved by Gibbs, seconded by McEwen to accept the high bid of 31,500 for 315 North Fifth Avenue. Is there any discussion? If not, all those in favor will signify by saying aye.
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 Opposed, no. That motion carries unanimously.
All right, excuse me, number C, 1111 West Bridge Street. I have 6 bids for that property. The appraised price and the sale price that you all set was $8,000. And bid number 1 is for $8,500. And that is accompanied by a money order in the 10%. Bid number 2 is in the amount of $23,010, and that is also accompanied by a bank check in the 10%. Bid number 3 is in the amount of $10,105, accompanied by 10% cashier's check. Number 4, the bid is for $14,500, accompanied by 10% bank check. Bid number 5, $15,800, accompanied by 10% bank check. And bid number 6, in the amount of $15,000, accompanied by 10% bank check.
We have a high bid of $23,100.
No, 10. 2310.
2210.
$23,010.
10.
Right,
2310.
$23,010.
All right, 1 0 in the wrong spot. Hey, what are your wishes?
Make a motion to award the bid of 1,111 West Bridge Street to the winning bid of $23,010.
Is there a second?
Fisher to second.
Then moved by Gibbs, second by Fisher to approve or award the property at 1111 West Bridge Street to the high bidder at $23,010. Any discussion? If not, all those in favor will signify by saying aye.
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 Opposed, no. That motion carries unanimously. Next,
Next, D, 1405 Brady Street. We did not receive any bids for that property. Letter E, any other tax deed properties listed on the website. I did receive one bid for a property 2021-3. This was on the agenda last month, and we received no bids for that. We did receive one bid, and the bidder provided some photographs that are updated with the snow melt being gone or with the snow being melted away. And that is in the packet, listed packet 1 on the website. Christie was having some difficulty updating that packet. So the bid on that, or the appraised value on that, was for $8,000. And I have a bid in the amount of $1,000, accompanied by 10%, along with the pictures provided, the updated pictures.
and so was that an updated appraisal?
No, this
Okay.
was just appraised. It was appraised, I believe, it was in the winter. The appraisal pictures are all, have snow. This was one that was up for bid last month. We received no bids, so the process in the past has been the committee may consider a bid lower than appraised value if there are no bids received on the first time around.
Any thoughts on the part of the committee? What do we have invested in that property?
Not a lot. I would have to, I didn't bring that with me, I apologize.
What are the wishes? Can
It's a
you-
property that has been delinquent for a number of years.
Is this a neighbor?
Is that property in the packet? Or is that
It is in the packet, yes, it's under packet 1 on the website. The original appraisal is there. The original info that
What was the address of that property?
It's in the town of Bevent. 206-264 County Road J, town of Bevent. When we took this property, it's a single wide trailer that had the plumbing open to the ground. I don't know if you remember that discussion. Had the plumbing open to the ground, lots of trash, debris around the property.
Kim, did you say 206? 206-264 County Road J, town of Bevent.
All right, we have a bid.
So we would have $400 invested in for the appraisal and about $150 in maintenance costs to secure the property, in addition to the outstanding taxes.
Do you know how big the lot is?
We could pull it up. Does anybody have there? I don't, it's not real big. I think it's right at an acre, maybe a little less. If you'd like to, I can go get the information on that. We could move on to the next items and come back to it if that is what you would wish to do.
If no objection, we'll do that. So if you want to find that, and then.
I've got the next two, number 2, the tax deed properties setting a price. And then I could get the information while you're doing numbers 3 and 4,
Okay,
if you would like.
that would be fine.
Okay,
Just to answer Supervisor McEwen's question, I believe that's on page 26, and it's .743 acres.
Thank you.
All right, so setting the price for 11, well, do we need any other information relative to the property in the town of Bevent? Or what are the wishes? We can either accept or reject.
I'd still like to know what we have against that
I can pull the file and tell you what the outstanding taxes are,
All right,
certainly. So do you want to move on to
all
number
right.
2?
You want to move on to the Arthur Street?
Sure, 1128 Arthur Street, setting a price for that one. This is in the packet, under packet 2. The appraisal is there. The appraisal came back at $10,500.
What are the wishes of the committee?
Make a motion, to set the price at 10,500.
Gibbs moved to set the appraised price at $10,500 for 1128 Arthur Street in Wausau. Is there a second?
Leahy seconds.
Second by Leahy. Any discussion? If not, all those in favor of establishing that price will signify by saying aye.
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 Opposed, no. That motion carries. All right, B, tax deed properties sale 2005-6 and 2005-7, Village of Croninwater.
Okay, these were the two properties that we received the bid on last month. The properties were appraised at $16,000 prior. We got the bid. You all directed me to obtain a new appraisal for that, which we did. The appraisals came back at $11,500. So the appraisals are lower. So my question to the committee is, would you direct me to relist those for sale from scratch? Or are we simply updating the purchase price on the website to match the new appraisal?
Which process tends to get more notice and interest?
Well, probably relisting them. We would have to relist it in the paper, go through that process. We'd probably have to start with the departments and the municipality to see if they had any interest in the properties, if we're going to start the process from scratch. Or you could direct me to relist them. I don't know, Corp Counsel, if we have to go through the process from step 1.
I don't think that we're required to do that. I think you can elect to say, okay, now we have a better, now we have a better idea of what the market would bear regarding something that was less than the original appraised price. and go back and relist it. On the other hand, obviously, I think this committee could decide that it would be in the best interest of Marathon County to begin the process over again. I think it's been way more than 2 years, right?
Been 15 years.
Yeah,
right?
so, our ordinance talks about accepting bids that are less than for a period of 2 years. So, I think it is within the discretion of the committee, but those are the considerations.
Mr. Chairman, yeah, since, we've got a new appraisal, and it's been some time, I think we should go through the full process of notifying the municipalities and relisting the property through the full process, and I would make a motion to set the purchase price at $11,500, the new appraised price.
Is there a second?
McEwen, second.
Second.
Moved by Gibbs, seconded by McEwen to begin the process again and set the price at $11,500. That's for each property, correct?
Correct.
Kurt, that was for both. All right. Any discussion? If not, all those in favor of establishing the price will signify by saying aye.
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 Opposed, no. That motion carries. Thank you. All right, possible taking of property, 1 acre lot in the town of Spencer.
All right. The property is located in the town of Spencer. It's a 1 acre vacant lot. The taxes are delinquent from 2013 to 2020. The total payoff is currently at $798.47. Of that payoff, $476.19 is unpaid taxes. $322.28 is interest and penalties. And there is some additional fees for the tax deed process that needs to get added on just for certified mailings. An environmental transaction screen was done by Marathon County Health Department on April 13th, 2021. At the time of the study, the property was a vacant lot not serviced by municipal sewer or water. The study did review that a barn and silo was on the property and has since been removed. The study did question the property lot lines, as the neighbor to the north looks like it might be encroaching it, and the property to the south is farming part of it. Connie and I drove past the property on May 6th, and based on a visual, it appears to still be a vacant lot. Images are in the packet from that drive-by that's included on our agenda packet. The neighbor to the north looks to be using the property for driveway access to County Road F. Also do not know if his house is near the lot line or not, as you can't see the stakes from the road. Around 2 years ago, a real estate agent called the treasurer's office and talked to me. The neighbor to the north, the agent claimed the neighbor to the north buried a barn, silo, and other appliances on this property. Based on the aerial image and the environmental transaction screen, there was a barn and silo on the property in 2015, and now there is not. Since the phone call, the neighbor sold the property in 2018, and the new guy, I believe, knocked down the house on that property and built a new one, or is in the process of building a new one really close to this lot line today. On April 26th, the new landowner to the north called asking to be notified once the county owns the property, as he's interested in acquiring it. He also called this week and told me that he believes the barn is buried on the property. I know we talked to the health department and about the barn being buried there and possibly other things, and really unsure on that. We can't dig to see if it is buried there. We don't know if it's true without any other without guidance from the board. And we also don't know where the lot lines are without it, without surveying it or finding the stakes. And I don't know if we have access to do that, so.
The lot also is being farmed, but only part of it is actually being tilled under. So you can see that there's rough spots there. So that possibly could be where the barn is buried, because he didn't come up all the way. Previous to us visiting the site, it looks like he created another driveway next to it. And when he initially tried to take this parcel, there was no additional driveway, so he has two, so it makes a U out. I guess the current owner of the parcel next to it that's building the brand new house wants to purchase this 1 acre. So he pretty much wants us to take it, and then he wants to do the bid process, but there's no guarantee that he's gonna get it. But he does have a driveway on his parcel now, so technically he's using both. So half of that driveway, if you look at the pictures, that first driveway, he is utilizing that also, which is technically not his. It's on that 1 acre. And that 1 acre is a different owner, and that owner no longer is surviving. And the person that's building that house indicated that he cannot find anybody that owns that property other than the one who passed away. So that's kind of why he's looking for the county to pursue taking the property, because he wants to eventually purchase it, but he doesn't know how to.
Just for future reference, and Scott, correct me if I'm wrong, but if we have concerns over a property prior to taking it, I think we can obtain an inspection warrant to do geotechnical work on those properties. So keep that in mind as one of the tools that's available to you. But what are the wishes of the committee with the recommendation? Is the recommendation that we take the property?
Well, it's up to, we talked with Scott on that, and I thought we were either a guidance from the committee if you wanted us to spend more money on the tools to dig and find more, or if you want to take the property, it's up to the committee.
Or do we want to recommend to the current owner of the existing, I don't know how big his parcel is that he's building the house on, a way to maybe find out who could possibly own that property, and just let him decide, because the taxes that are owed on that property is under $1,000, so.
And the county currently settles for about $65 to $70 a year on this property with taxes. So I don't know how much, the county or the board would want to spend in the studies or any of that.
And the reason that the treasurer's office actually pursued the properties, because we've been contacted by real estate companies asking for us to look into it. So that's why it's on the board, and we took this off before when we had the other ones, because there was no environmental study done on it yet.
So what are the wishes? So we have a very cursory transaction screen that was conducted by the health department. We don't have any formal recognized environmental conditions. We have concerns relative to the potential burying of buildings and structures on the property. We have outstanding taxes and interest, and just under $800, and some transactional cost. What are the wishes? Any thoughts?
Chair Robinson, Supervisor Fisher here.
Go ahead, Jonathan.
It seems like if we had any more solid agreements with the property owner to the north, it would be a good idea. However, at this time, if that transaction would not go through, and or they would not be interested in purchasing this property, this seems like something we'd end up holding on to forever. And I know we're currently back taxed on it by roughly $800. But it seems like there might be some additional information we need to gather before we go down the road of taking this and hopefully turning it for a sale, at least at this time.
I don't believe we can enter into a negotiated agreement relative to a tax deed sale under law. A municipality could, the town could, but we cannot enter any agreement like that. We have to go through the formal bidding process with a private party, so we're limited.
Correct, which is why I'm a little concerned we'd end up holding it for quite some time.
Question, Scott, if we took the property and resold the property as is there any potential liability if the new owner were to discover items buried when the foundation of the barn was buried? Could they come back to the county, or would the property be sold as is, and buyer beware?
Well, I think that there is some risk here of that happening because the transaction screen was done from the road. It's my understanding further that we really have tangible information that really leads us to believe that there are things buried there. And it's my understanding that these folks from the treasurer's office went up there and actually walked the property, and it really does appear that there's something buried there. So I do think that there's some significant risk here. One of the things I did ask about is whether or not, the town has expressed any interest in acquiring the property, and I don't believe that they have. I do think that there's a risk here, and I don't know that the reward is very substantial. So that's my thought.
But I don't mean to correct you, but I will. Under 292-12, I believe, of the statutes, there are local governmental exemptions from liability if the properties are acquired through a sheets, tax deed, foreclosure, and others. So this would qualify for that. And that would grant you liability protection under the state law, and the state couldn't come after you and force you to clean it up unless you change the use. However, that doesn't protect you, as Scott said, from third-party liability and that lawsuit. Typically, in order to give you that protection, you would want to know what's do what's known as an all-appropriate inquiry. Phase 1 environmental assessment that would formally identify recognized environmental conditions. Undoubtedly, the buried material would be a recognized environmental condition. You could sell as is, but and then you would have flagged it. But the screen doesn't meet the standards of the ASTM protocols, which are sort of the best practice, and would give you more protection should the suit occur. So you do have liability protection, but that's always good until somebody sues you. And having worked in that area for...
Is if the town were to acquire the property, would they inherit the liability that the county was inheriting if they were to, in turn, resell it to the homeowner that is building the new home?
Liability for environmental conditions rests with the causer, the responsible party, or others. If we acquired it through tax foreclosure, and particularly if we had a negotiated agreement, which is, I think, on the agenda later, we could convey our liability exemption to the town, and they, in turn, would have that liability exemption as long as they owned it until they put it into use. But if they sold it, the party that bought it does not enjoy that liability protection. So we can convey from us to another qualified entity in that chain, but it doesn't transfer to a third party. That's where that all-appropriate inquiry standard and doing it to the, that recognized environmental condition and proceeding is important. So.
Well, I think, Mr. Chairman, if I might, if we do nothing, the property is going to continue to sit there. There's no question. We're going to continue to have back taxes. sitting on that property. So my recommendation would be that we do the full transactions screen, and that means if we got to go dig the foundation to find out if there's stuff buried there, we do I know that adds cost to the property. However, we're going to be adding cost to the tax base also. If this comes back clean and we take the property, obviously the homeowner that is building a new home is going to want that property, and it's going to add more significant value to the residential parcel with it cleaned up and put back into tax base.
So would your, just for clarity,
My
you would
motion
then...
would be that we fully do a research and clean and environmental inspection of the foundation of that property and
So
see if
would-
there's anything buried there.
For clarification, would that include a inspection warrant to get us access to the property for the geotechnical work?
Absolutely.
Okay. So with that motion, is there a second?
Second.
Any discussion? I think that personally, that's a prudent approach. Anything?
The only thing I would consider, looking at these property maps, you know, if the southeast corner of that property is being farmed by, I would think the surrounding farmer, does that cause any trouble with them going over the property line?
It's not our property yet. If we buy it, then we can say something about it, but it's not ours at this point, so.
Okay. Otherwise, I agree with the current motion.
Any other discussion? Any other discussion? If not, all those in favor of the motion will signify by saying aye.
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 Opposed, no. That motion carries. All right, next. Addressing penalties and interests associated with delinquent special assessments levied against 909 South 60th Avenue in Wausau. Scott, do you want to?
Sure, and I think the folks from, I think Connie has some additional information about this property as well. This was a piece of property in the city of Wausau that was subject to special charges that were forwarded by the sewer and water utility to Marathon County. Marathon County paid the settlement in the amount of $28,255, I think approximately. It's my understanding that the property owner has since disputed that with the city, and the city has voted to accept a settlement offer whereby I believe the property owner pays $5,000 to the city. The city, upon receipt of that, will refund the entire settlement amount to Marathon County. I believe that the city's position is that there were notice problems from the very beginning with this, and that this was not an appropriate use of the taxing mechanism in this particular case. Given that, I believe that the tax itself that's owed is void. Now there are interest and penalties that have accrued to that amount, but if the debt itself is void from the very beginning, there's no interest and penalty that's due and owing because the property owner is not subject to that tax. It is my understanding that the city has voted to pay Marathon County that. I think the treasurer's office, I think Connie knows how much that actual interest and penalty is?
The interest and penalty on the total property is $15,435.65. There was actually two charges in, the city put on in 18, delinquent miscellaneous utility charge of $21,397.78. And then in 19, they did another one for $26,869.07 for a total of $48,266.85, and they want to settle for the $48,266.85 with taking off the delinquent penalties and interest. The parcels have been paid for. They've always paid their normal taxes on them, so they're not delinquent in that respect. It's the utility charge they refuse to pay.
And essentially, my understanding is the city has acknowledged that that was not an appropriate charge. So I'm not, what we have stood very firmly on in the past is that the county does not have the authority to forgive interest and penalties to landowners who come in and say, okay, well, we want to make a settlement here. You do not have the discretion to forgive those things on a case-by-case basis. But in this situation, it's the municipality acknowledging that the use of the taxation was not an appropriate collection method in this particular case. So I believe that the debt is void. I believe that the interest and penalty is also void because it's not a charge against the landowner in this case. We have looked into this somewhat, and it's my understanding, I did have a conversation with Christy earlier in the day. It's my understanding that the Treasurer's Office is able to void the interest and penalty in this case. It is my understanding that our auditors really look at a threshold of approximately $50,000, that this would not necessarily raise any eyebrows with our auditing team if this debt is voided. Am I stating that correctly, Christy?
Yep. Yeah, and we still are in communication with them, so we'll just follow up with them too. But I don't see that as being a problem as long as it's well documented in the minutes.
All right.
And
I just
that
have two more
associated.
cents, Mr. Chair. Essentially, the way I've looked at these things is that essentially Marathon County purchases, by making these settlements annually, Marathon County purchases these debts with the incentive being the penalty and interest that we can then charge for the money that Marathon County has put out there. This, at the end of the day, I think can be regarded as like a loan to the city of Wausau in this regard. And we did look at what federal interest would be on that loan if it's less than 3 years old. The federal interest rate would be less than 0.1, or I'm sorry, would be just over 0.1%. So if we agree to this, essentially, we're foregoing very little actual interest if we were going to make a claim against the city. So I think the committee has the power to agree to this in the event the city makes that payment, and can waive any nominal interest that they might have been entitled to by virtue of the loan theory, if you will. Thank you, Mr. Chairman.
Let me put on my City of Wausau. It's actually the Water Works Commission that made it versus a city. So this goes back to a situation where the property was annexed to the city, and they had a unused well on the property, and the city ordered it to be properly abandoned. It was not abandoned. After repeated notifications, they started accumulating fines and forfeitures. and it was resulting in the $48,000. The current owner, who we think is the owner, but is the 50-year lease, he has an opportunity to sell the property, and they've offered a settlement to the city. I would suggest that in order to make sure that we get the payment, that we condition our forgiveness of the interest upon their settling of the amount of $48,000. If we can, and that's been with discussions with the city.
Thanks. The term I'd use is void as opposed to forgive.
Could void upon the receipt of the payment. That would keep the pressure on the third party to make the payment to the city, in turn to make the payment to us, and hopefully resolve the issue. So, are there any questions?
I make a motion to accept the 48,266.85 in settlement and forgive the interest. Avoid the interest if and when we receive that payment on those charges, because the charges were invalid.
Is there a second? Could we delete the
Second by-
last invalid charges?
Yeah.
There is a second by Leahy? Any discussion? Any discussion? If not, all those in favor of the motion will signify by saying aye.
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 Opposed, no. That motion carries. Thank you.
One question, how much was the amount of payment that was owed for the minutes? For 46,
48,266.85.
All right. Kim, you're back.
I'm back. Back to Town of Bevent. The outstanding taxes are $14,244. The appraisal for this property, he only charged us $200. The appraisal was $8,200. And one note I had here from when we took the property, CPZ has requested to be involved, notified of any sale to make sure the pout system is abandoned properly, because there's raw sewage underneath the trailer from where the plumbing was emptied onto the ground for many years. So the total county investment that we have with all the expenses, $14,826.69. And the appraisal was $8,200.
And the bid was 1,000.
Correct.
So what are the wishes? Of the committee? The options are to accept or reject.
Mr. Chairman, the price was set by the committee, but we received no bids for.
Correct. We didn't receive any bids last month, which is the first month it was available to be bid on.
Is our process then, it is re-advertised? I'm a little.
The process is that if there are no bids received the first time around, the committee may consider bids lower than the original price or the assessed set price, appraised set price.
So what are the wishes? It's a new property we have a.
Is the question, is the bidder an adjacent property owner?
I don't believe so. The bidder's address is 3287 Twin Lakes Road in Rosholt.
Chair Gibbs, quick question.
Go ahead.
Do we have any idea, and maybe this is a question for corporate counsel, if we sold this property for the $1,000, would that eliminate any liability due to the mitigation needed because of the raw sewage being there on the property? Or would we have to clean that prior to the end of the actual sale?
That would likely be an instance of a sale as is, since it is an open and obvious condition.
Any thoughts, motions? If there are no motions, we will defer this to a future meeting.
Mr. Chairman, I make a motion that we accept the $1,000 bid and get the property back on tax roll, and the winning bid is going to be charged with obviously cleaning it up and making sure that the septic system is closed properly.
Scott, is that seeking a release for the county? Can we do that?
I'm sorry, I'm thinking, the pause here. I apologize for thinking.
Get used to it.
Yeah, really. Obviously, the idea of a release appeals to me because I'm always very concerned about the risk to the county. I don't know. I don't know that, well, I think of the language of our ordinance and the language of the statute talks about a bid most advantageous to the county. Our ordinance actually does helpfully set out some criteria for you to look at if you are talking about what's most advantageous to the county. And so the first, obviously, is the amount of the bid. The second is the future use that's projected for the property. The third is whether or not the property would go back on the tax roll as a result of this particular sale. And the fourth is protection of the health, safety, recreation, and welfare of the citizens and visitors to Marathon County. So I'm looking for a way to make this happen. And I think if you say, as part of our consideration of what would be in the best interest and most advantageous to Marathon County, that we will accept this bid less than the appraised value, conditioned upon the signature of a release. And I think we would probably say and intention to rectify that situation. Then I think we'd be within the realm of protecting the health, safety, and welfare of the people of Marathon County.
What was that?
That was my motion.
Okay, is there a second? Is there a second?
Second by Leahy.
Fisher to second.
Okay. All right, any discussion? Chrissy, you got that?
I have a motion by Gibbs, second by Fisher, to approve the bid at $1,000 and accept the bid less than appraised value and accept a release from the bidder to clean up the property.
A release of liability.
Release of liability and
Got it.
statement of intent to clean up the property.
Release of liability and statement of intent to up the property. Got it.
Any discussion?
Do we need to include something about they need to work with CPZ per CPZ's request, or no?
I think that's implied in the,
Okay.
is there any discussion? If not, all those in favor will signify by saying aye.
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 Opposed, no? Thank you. That carries. All right, discussion, tax deed at 213-404 West Main Spencer.
This is a tax deed property from 2013 that has been occupied since 2013. And we have a request for it to be allowed to be continued to be occupied. So Scott has worked some with the occupant.
All right, so you're throwing this to me as well?
I am.
All right. So this is a piece of property that Marathon County already owns, and we've owned the property since 2013. And you have authorized us to go ahead and begin the eviction process with a number of properties that Marathon County owns that currently have folks living on that property. I asked that this matter be put on the agenda today to basically report on it. There is a Mr. Comas who is residing there. I did send an email to his attorney, Sam Hutchison. So I just ask if either Mr. Comas and/or Mr. Hutchison is attending this meeting. Okay, hearing nothing. I basically, my plan is to just report to this. I received correspondence from an attorney through Wisconsin Judicare indicating that he does represent Mr. Comas with respect to this property, and indicating, yes? Oh, okay. I indicated to the attorney that Marathon County is observing the eviction moratorium, the federal eviction moratorium. Some of you probably know that there was a federal decision last week that overturned the moratorium, but then the federal Department of Justice appealed the case, and a stay was granted. So the moratorium remains in place until June 30th. We have served the current occupant with a 28-day notice to quit. The next step, once the moratorium is lifted, would be to commence an eviction action. So I understand my directive to include that. But I'm asking at this point if you want me to reach out. We do have two other occupants of properties that we've entered into leases with pending this moratorium. Obviously the time is shrinking. At the time we entered into these other leases, the moratoria tended to be extending. We didn't know how long they were going to last, so we went ahead and negotiated with these folks for temporary leases. I have not done so with this individual. Obviously, I have an attorney that I can be in contact with. If you want me to try to do that, I will. So I'm seeking direction on that. The other thing is to just indicate that I have every reason to believe that this particular individual is going to want to appear in front of the committee possibly next month to plead his case as to why he should not be evicted, and that we should allow him to live in the property pending Marathon County's sale. So that's a warning. I assume that that's what's going to happen. But in the meantime, we will file the eviction action when the moratorium expires. I am asking for your direction as to whether or not to negotiate with him regarding a lease.
So can you give us, so we've been carrying this for 8 years. What were the special conditions that led to the initial lease?
My understanding is that, and I believe I was the corporation counsel at the time that this happened. So I believe this individual came and appeared in front of the committee indicating that he was a veteran who I believe said he had a motorcycle accident, had suffered a head injury, and was in no condition to be able to vacate the property. At the time, the committee said, okay, we'll defer an eviction action, and basically placed it in the hands of the clerk and corporation counsel. This is one of these cases that has not moved since that time. I believe that the committee at that time found him to be a sympathetic individual. But I think times change, and decisions are going to need to be made, and we stand ready to execute what you've told us to do.
So is there any direction to corporation councils? You will begin the process or have begun the process?
We've actually begun the process. What prompted this was we served him with a 28-day notice to quit the premises. And the response then was to obtain legal representation and point that out to us. And I said I was very well aware of the eviction moratorium, and that the county had instructed me to proceed, but to obviously observe the federal law as we do so. So since there's a moratorium against further action, we haven't taken it. But obviously we will go ahead with the next step once the moratorium expires. In the meantime, do you want me to try to negotiate a temporary lease?
Mr. Chairman, if I might.
Go ahead.
Well, to be consistent, any of these other properties that we currently own that is occupied, we do have leases on. Is that not correct, Corp Counsel? As a general rule, we always instructed that we negotiate a lease because of liability for the county, and negotiated those leases in most situations, I should say.
Since the moratorium, since the pandemic and the existence of the moratorium, that's what you've had me do. But not before then. We certainly had folks that were saying, no, we don't plan on leaving, and we have gone ahead and prosecuted eviction and gotten rid of assistance in order to evict individuals. So, but to be consistent with your policy, in the wake of COVID-19, we have negotiated leases.
Well, my motion would be to instruct Corp Counsel to negotiate a lease to be consistent with our policy in this case, even though We have started the eviction process that has been put on hold by the moratorium, but yet will continue when the moratorium is expired.
So the leases to run concurrent with the moratorium and eviction begins after that,
Correct.
for clarification. Is there a second?
Leahy will second.
Any discussion? If not, all those in favor will signify by saying aye.
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 Opposed, no. That motion carries. All right. Now we're at the Habitat for Humanity donation. So who's taking the lead on this one?
I was contacted by an attorney who represents Habitat for Humanity, and they are in possession of a piece of property at 1312 North 16th Avenue. That property adjoins one of the properties that we own via tax deed at 1308 North 16th Avenue. Attorney Espinoza wanted to know what the process would be for Habitat for Humanity to just give the county their piece of property. And I believe he's on the phone. So Attorney Espinoza, if you wanted to present your thoughts with the committee.
Sure, thank you very much. I appreciate your time this afternoon. Again, my name is Attorney Marco Espinoza. I am a board member for Habitat for Humanity. I've been on the board for the last 3 years. And in my spare time, I'm general counsel here at Greenhack Van Corporation. So I decided to help Habitat with this dilemma here. 1312 was acquired by us in 2013. I wasn't around at the time, and nobody who's on the board was around at the time, so we don't know the history around what research was done on the property before acquiring it. We acquired it from the First Church of Nazarene Wausau for about $36,000.
You're echoing. I can't hear anything.
He's coming through okay here. Are others having trouble?
Okay,
Yes.
Okay.
is this better?
Yeah, that's much better.
Yes. thank you.
Okay, I'm sorry about that. I was on earphones in order to cancel out any sort of outside noise. But if this is better, then I apologize for the previous disruption. So, Habitat acquired this property, and unbeknownst to the board at the time, it is a wetland. We were notified 2 years after we acquired the property. The U.S. Army Corps of Engineers and the DNR completed a wetlands delineation study on that lot, and it ends up that lot is classified as a wetland. And so, the mission of Habitat is to put families in substandard housing into homes, and the only mission we have is to own property that eventually we'll be able to build on, and we're unable to build on this land. It was assessed in 2021 for $2,700. We had not been paying any taxes on it. Recently, we completed a property tax exemption request, which was rejected by a city assessor recently because the property was acquired 7 years ago, and it's 4 years beyond the required by law assessment date. And so, we understand the need to assess taxes on this property, but this isn't a property that we can really retain, given the mission of Habitat. We do have an adjacent home. Habitat home number 57 was built on the adjacent lot to the north of 1316. We contacted the owner to try and sort of gift the property to him, but they didn't want it. So we believe we've exhausted our efforts. We don't want to just not pay the taxes and end up being a agenda item on operational functions for that committee. So, but what's interesting to me from hearing your discussion over the last hour, it seems like you have a lot at 1427 Lake Street. So maybe there's a switcheroo we could do here. If that's a buildable lot, you know, it's what we're always looking for. Habitat is always looking for lots that the cities, municipalities, and counties of this area are willing to negotiate with us so that we can, you know, put a home on that lot and put it back on the tax rolls. So I'm not sure what the deal is with that lot, but this is the information that I was asked by the Board of Habitat to present to the county.
Scott, let me put you on the spot and ask the question, is it possible to do a land swap?
I don't think so, because again, that would be, the other lot that he refers to is tax deed property. And we're just, the only people that we're allowed to reach agreements with are other municipalities. So we're not able to negotiate a sale. Certainly if they wanted to put a bid on the property, they could go ahead and do that. And even if it was less than the appraised value, this committee would have the authority to make a determination as to whether or not they were willing to accept that bid. So we'd have to follow that particular process. With respect to the offer of the donation, I don't know if Attorney Espinoza had any further comments on. My understanding is this is an offer of donation in order to sort of short circuit or shorten the time period, not have to go through the other process of taking it by tax deed.
That's correct, Corporate Counsel. We just don't want to create more work or any bad blood between Habitat and the county. We always have good relationships, and you know, if it were to go to the issue of us having to carry it and not pay taxes, we just don't think that would be being a good citizen of the community. We would rather just donate it to the county. There are no back taxes owed on.
So my comment on that is that the statute does permit us to acquire property that is adjacent to other tax deed property if we believe that it's in the best interest of the county to do so. So I believe it talks in terms of purchasing it, but I think the statute is broad enough that it would allow us to accept the donation of the property. Donations are always in the discretion of the county, however. And I think what we would do is probably run this up to the full board. If this committee decides that it wishes to accept the donation, the board reserves the power to accept donations on behalf of the county.
So are there any questions of Scott or Attorney Espinoza? Any questions? If not, what are the wishes of the committee? The options would be to do nothing or to recommend to the county board that we accept the donation of the property.
Supervisor Stark, I would make that motion.
To accept the donation?
Yes,
And recommend that to the.
and move it to the full board.
Okay, is there a second?
Fisher to second.
Moved by Stark, seconded by McEwen. Any discussion? If not, all those in favor will signify by saying aye.
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 Opposed, no. That motion carries. Thank you.
Chairman Robinson, can I get an address on the Habitat property?
Sure, the Habitat is 1312 North 16th Avenue in the city of Wausau.
All right. Next
It
item.
probably has a lot of standing water by now and quite a few reeds. So So it's obvious from a layperson's perspective that it's 60% or greater is wetlands right now.
Okay. Next is discussion and possible action on tax deed property in the town of Rib Mountain.
All right, this is a tax deed property that we've had for quite some time. When we put out the notifications to the municipalities, the town of Rib Mountain did indicate that they were interested in acquiring this property. So we have, from the town of Rib Mountain, a signed purchase agreement. The appraised value was $17,000. And the signed purchase agreement is for the amount of $17,000.
What are the wishes of the committee? What is
Stark,
it?
move to accept.
Moved by Stark, is there a
The,
second? Is there a second?
Second by Fisher.
Seconded by Fisher. To accept the purchase agreement on the tax deed property in Rib Mountain. Any discussion? If not, all those in favor will signify by saying aye.
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 Opposed, no. That motion carries. All right.
Thank you, everyone.
Thank you. Approval of claims, April claims and question costs. That was distributed last week by Christie. Any questions? Any questions? If not, is there a motion?
Motion to approve.
Moved by Supervisor Lay. Is there a second?
Second by Fisher.
Seconded by Fisher. Any questions? If not, all those in favor of approval of the April claims and question costs signify by saying aye.
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 Opposed, no. That motion carries. Item 9 is determination of eligible special assessments and special charges for payment under 7429 Wisconsin statutes. I requested that that item be put on the agenda, and it stems from the earlier discussion relative to the property on Sherman Avenue. Under 7429 special, the county has the option of paying or buying back at the time that we reconcile the property taxes with the community's special assessments and charges. The situation that we had earlier today was a case where inappropriately the charges were put on the property, and they should have been adjudicated through municipal court as a fine and forfeiture. But as a result, the county had basically reimbursed the city $48,000 for those fees and forfeitures. And I wanted to begin a discussion about under what conditions do we want to pay for special assessments and special charges? And is there a review mechanism that we can put in place to try to avoid this situation in the future? And again, the statutes appear to be discretionary in the county's role of assuming and buying the tax rolls and special assessments in the past. Those assessments have been, in many cases, hard to recoup at the time of a sale, and in light of the time, perhaps we can defer it to a future meeting, but I would like to just begin the thought process on how we might go about evaluating what the county's role should be in the future. And Scott, have you had a chance to look at the stats?
I'm sorry I haven't. So I'm sorry. I really, I haven't had time to really analyze it at all.
So in light of that, I would just defer that to a future meeting, and we will get to it. But I think that what we want to do is, perhaps talk to Connie and staff and others and see if there's a reason for us to revisit and clarify our policy going forward, and to see, where special assessments and those special fees and charges have, we've been able to recoup those and where we haven't. So without objection, we'll leave that to a future meeting. We'll move on to B, the discussion of the intergovernmental budget transfers. There were a significant number of those for ADRC, CW, and other departments. Christie, is there anything that you'd like to highlight?
Yeah, Steve, Supervisor Robinson, if he would like a job, can work in the finance department. There are two on page 44 and 46. The revenues and expenditures should be changed for the ADRC. The ADRC is a separate governing board that approves these transfers. They're coming to you because we run we're their fiscal agents, so they've already been approved, but by your review means the finance department is then changing appropriations within another governmental entity's budget. So that's why you see them, just so that we have our committee saying, yes, please make those changes in the budget, but they have been approved by their committee. And the other ones then are those for the county, many carryovers, and one additional grant, I believe for the health department. They had a change in an increase in revenues, and that's it.
So we need to adjust the transfers to decrease revenue, or excuse me.
Yeah, I received those from Steve Prowse, so we'll just approve as amended by the ADRC.
Okay, all right.
And they've already been approved by their governing board. It's really just for when the auditors come in, they can see that when the finance committee or finance department makes those, because they are budgetary changes, that our oversight committees reviewed them and said, yes, please go ahead. But their board really is the governing body that made the decision on those. We just want you to make sure that we're doing things as approved by our committee as a fiscal agent. And then the remaining ones are truly those of the county, and those you do approve, with one being an increase in revenue that will go to county board.
Okay, any questions or motions?
Stark, move to approve.
Is there a second?
McEwen, second.
Motion by Stark, seconded by McEwen. And that would be EJ reflected of the changes that we received today. Okay. Any discussion? If not, all those in favor of the transfers will signify by saying aye.
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 Opposed, no. That motion carries. Next is to amend the CIP for the transfer in the amount of $314,925 from the highway for the highway bridge projects, and $225 for the design work of the county highways AAH, XJ, and QG intersection in bridge B088. So is that, Christie, are you going to handle this, or Lance?
I think Jim Griesbach
Or is Jim on?
had taken it to, yeah, he's on it, and he took it to infrastructure, and we reviewed the funding and believe that we are able to make those changes within his budget. And I will have Jim speak to the nature of the reason why it costs more to build stuff.
Go ahead, Jim.
Thank you, Christie. Yeah, we last year we had talked about going out and borrowing some money for a couple of reasons. One is we have a ton of bridges here that need to be upgraded, and we could put this new bridge decks on them instead of letting the bridges collapse down. We had that conversation last year. And also with that, we're going to lose a couple major projects on our 6-year rolling average for our GTA, so we needed to increase our funding to get to keep our balance, our funding level the same for our GTA fund. So we came up with about 5 bridges early last year we had kind of estimated those bridges to run us about $1,230,300. Well, if any of you have gone to Fleet Farm or Menards or Home Depot lately, you've seen everything has gone up in the construction costs, and it's no different in my world with the bridges. So we did let in those 5 bridges on April 6th. We had 3 bidders. The low bid was Zenith Tech at $1,544,924.50, giving us that shortfall of the $314,925 that you see on your cost today. So we like to go ahead with those 5 bridges. We feel it's the best interest of the county, and we want to get these bridges repaired before we start looking at full replacement. A full replacement of the 3 smaller bridges, you're probably looking at around that $600,000 mark each. And the larger bridge, you're probably well over $1 million. So it'd be best interest if we could repair them now before they go down the road farther. Do you want me to cover the design work right away, or you want to talk about that one first?
I think we intend to take those as one motion, so go ahead.
The other one we talked about in the Wisconsin County Highway Association, and we were hoping for different news today regarding the funding mechanism for the recovery plan. But we also want to be ready for America's job plan that's out there, which is really going to emphasize bridges and highways. What I want to be able to have ready is when they start saying, Jim, do you have a shovel-ready plan? I can turn around behind my desk and say, yeah, I have one right here. And they say, well, that's great. You have another shovel-ready plan? I can turn around and say, yes, I have another one right here. I have 6 projects total that I'd like to get into design phase. Since infrastructure even met, I just have received notice for the 2022 to 2027 surface transportation rural bridge and STP rural road projects are coming out. I'm going to need plans for these anyhow. So with these 6 plans that I wanted to prepare to have shovel ready, approximately 5 of them, 4 or 5 of them, I'm going to need plans for anyhow. One project is County Trunk Highway J from 153 to 29. I applied for BIA, Bureau of Indian Affairs, funding for that. I feel I have a good chance of getting funding for that, which I would need plans for. One of them is the intersection of Highway Q and G, which was identified as one of our most dangerous intersections in our recently approved county roadway safety plan, which I would need plans for. The bridge B088, which is on County Trunk Highway L, east of 107, kind of where Pagel's restaurant and bar is and down to that area. I'm going to be submitting that one. It's one of my top bridges for replacement on the SDP bridge program. County Trunk Highway X from 153 up to the Bull Junior Bridge. That one, now that I have STP rural funding coming for that, I'm going to apply for funding for that one. And we also have 2 other projects down in the southwest part of the county I'd like to get plans prepared for. Is County Trunk Highway AA from the county line to 97. We should really look at engineering at the intersection right where we meet up with Wood County down there. It's kind of a bad intersection. And the other one is County Trunk Highway T from the county line to Highway 97, which we'll probably have to take a good engineering look at, because that is kind of in the bike and bed plan, so we would need some plans for that one. So kind of my estimate, going through what I've been through, I estimate that we need about $225,000 to get those 6 plans on the shelves. But again, at least 4 of them, I know for a fact that I'll be applying for other funding if there is no shovel-ready projects for America's job plan.
So Jim, that's AA versus AAA?
That's AAA, excuse me. I said double, it should be AAA.
All right, any
And
questions?
with Jim's discussion, that's why we feel that we just use fund balance, highway fund balance. And then as funding sources become available, we would offset that with those funding sources. But I think he's taken a great initiative to get this going, and he'll continue to pursue whatever other funding sources are available so that we can continue to work on getting those things done.
I'll just interject, the general transportation aid is a 6-year rolling average, and we've got some significant projects that are rolling out of that 6-year average, so it's important for us to if we want to maintain our state funding level, we need to make sure we're backfilling and keeping projects in the work. And this also gives us the flexibility to capture those outside funding sources should they be available. So it's a prudent and foresighted look on the part of Jim Griesbach. So what are the wishes of the committee?
Supervisor Fisher here to make the motion to accept both items for the 114,000 as well as the 225,000.
So amend the KIP for those amounts?
Correct.
All right, is there a second?
Supervisor Leahy seconds.
So moved by Fisher, seconded by Leahy. Any discussion? If not, all those in favor will signify by saying aye.
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 Opposed, no. That motion carries. Final item is resolution county land exchange in the town of Easton and Harrison. Is Tom with us?
Yes, thank you, Mr. Chair. Just briefly, I'll summarize the land exchange. Hopefully, you guys got a chance to look at the pack of information that was included in with the agenda. But briefly, in 1967, Mr. Robert Bitsky, in his will, gifted 80 acres of land to the county. At that time, it went to the Public Welfare Department, now known as the Social Services Department. A few years passed, and since Social Services doesn't really deal with lands, the Social Service Director at the time asked the Forestry Department if they wanted to have this property, and a resolution was drafted, and the county board did that and transferred the lands to the Forestry Department. And with that, the land was basically put aside for trading block for lands within the county forest. And we were just recently, about 2.5, 3 months ago, approached by the county from a Mr. Al McGowan if we'd want to trade 80 acres of land for 40 acres that is bordered on 4 sides of the county forest. So the Forestry Committee wanted to get appraisals, and we did that. He paid for one of the appraisals. The county paid for another of the appraisals. The land from the county appraised out at $256,000, and the land for his appraised out at $111,200 for the 40. We worked at an offer to purchase, negotiated through back and forth several times, and came up with something that looks like that possibly could work for both the county and himself. Basically, what it would be is he'd exchange his land, the 40 for the 80, with an additional $100,000 coming to the county, so that we could put that back into the forestry segregated land purchase account for future purchases. And we looked at that, so that it shows it's about a $40,000, $43,000 difference between the appraisals and the land exchange plus the $100,000. But we looked at that and said, well, he's got something that we would really like to acquire, being on 4 sides of county forest. The 40 also has has about 30 acres that could be harvested right now. So some of that money, I'd anticipate probably about $500 an acre, or about $15,000 would be a direct revenue back to the county right after the purchase would take place, or within a couple of years. If the county went to list the 80 if we would go that direction, we'd be paying a realtor fee. So these things sort of make up the difference. The Forestry, Recreation, and Zoning Committee and the Environmental Resources Committee unanimously approved moving this on to this committee for discussion. And we're looking, I guess, at potentially this land trade to increase the county forest land base. Again, meets the strategic plan and the county forest plan. And I did reach out to the town chairs of Easton and Harrison. They support the purchase, or excuse me, the land trade between the county and the private landowner. We had an environmental screen done on the property, which came back clear. And the title commitment that was done to make sure that there was no problems with the titles also came back clear. So I guess I'll stop there and ask the committee if there's any questions.
Are there any questions? Any questions? So, Tom, what's our, so we basically are giving for $43,000 to block in the park within our plan. If we were to go out there, is his desire to sell his property or to transfer the property?
So the way this would work out is the county would buy his property for $1, and he would throw in his property in exchange for that, which would be, if you looked at it, would be about a $211,000 transfer of his property from, or $111,000 of his appraised value, and then $100,000 in cash to the county, which would go into the Forestry Segregated Land Purchase Fund. The $43,000 that I was referring to was the difference in values of the land and the cash that the county would be receiving. And I try to, it sort of balances out with the timber that's available to be cut on the property, and that it meets the criteria of the strategic and county forest plans and blocking in county forests. It's something that is probably one of the highest priority lands that we've been trying to acquire over the last 10 years or so. If that answers your question, Mr. Chair.
Yes. Other questions?
No, Mr. Chairman, just one comment, I guess, obviously, there's still a $43,000 difference between the appraised values, but as explained, I mean, if we were to go out and solicit a realtor to sell the 80 acres and paid the average of 8% commission, you're talking roughly $30,000 in commission that the county would lose of the $256,000 asking price, and then the return of potential sale of timber. Even though I believe that the timber sale or the timber is included in the valuation of the 40 acres, we're still very close, but there still is, to the public, the view would be that the county should have gone out to a real sale and received the extra $43,000 difference. However, I think when you do the true math and look at the commission that would be paid, it's not as big a difference. And so because it is the number one priority on the Forestry and Rec Commission agenda and the long-term plan, and it is cited by all of our property, I think it's incumbent upon us to move forward with the transaction.
Was that a motion?
I will make a motion to approve and forward to the full board for its consideration the sale as described in the, spelled out in the conditions in the offer to purchase.
Is there a second?
McEwen, second.
All right, moved by Gibbs, seconded by McEwen. Any discussion? Any discussion? If not, all those in favor will signify by saying aye.
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 Opposed, no. That motion carries. Thank you. Our next meeting is.
Thank you.
Next meeting is May 25th at 4. We'll be talking a little bit about the American Recovery Plan and what our steps are. We'll have a little bit more clarification, and we'll be continuing to work on our work plan with items. Anything else? Any other announcements? If not, a motion to adjourn is in order.
McEwen move to adjourn.
Moved by McEwen, seconded by
Leahy.
Leahy. All those in favor?
Aye.
Aye.
Opposed? That motion carries. That's the most enthusiastic second we've had all day. We are adjourned.
No problem.
First was